Good evening. This is Radio Free Mormon. Back in November of 2021, I flew down to Salt Lake City for a debate with the Midnight Mormons. During that debate, Kwaku did one of the wildest ad hominem arguments against me that I've ever seen in my life. He brought up my career as a defense attorney as a reason for the audience not to listen to anything I had to say or to trust me in what I had to say about Mormonism. It was really quite incredible. It blew up in his face, as rightfully it should have. But this is what it sounded like in that debate when Kwaku went all ad hominem on me.
And I mean, these guys are nicer than me. I'm not going to lie. I don't think you actually have positive intent. And I think your lack of care for humanity and the divinity of souls it's evident on your podcast. You defended a teenager who chopped up his sister and put her in a freezer and tried to get those records hidden from the public. Okay. I mean, I don't think you actually have a care and love for human beings.
You have 3 minutes to...
So there it was, the biggest ad hominem of the entire debate, courtesy of Kwaku. Ever since that day, I've wanted to share with you the story about my representation of that young man who did murder his sister and stabbed her 20 times and put her body in the refrigerator or the freezer. I'll tell you the whole story on today's Radio Free Mormon. Stay tuned. Radio Free Mormon on the air, broadcasting behind enemy lines. Tonight's episode, the case of the boy who killed his little sister. Well, as I said, back in November of 2021, I went to Salt Lake City for that debate with the Midnight Mormons, and Kwaku not only accused me of this ad hominem argument of what I did for a living in this particular case, not only once, he also did it a second time. Here's both the first time without all the talking by Cardinellis, and the second time where he does it again only a few minutes later with similar results. In other words, the audience was not impressed with his argument. Here we go.
And I mean, these guys are nicer than me. I'm not going to lie. I don't think you actually have positive intent. And I think your lack of care for humanity and the divinity of souls it's evident on your podcast. You defended a teenager who chopped up his sister and put her in a freezer and tried to get those records hidden from the public. Okay. I mean, I don't think you actually have a care and love for human beings.
You have 3 minutes to defend
you're
yourself.
An attorney, you did that.
3 minutes. Let him have
Look it up. Google it. Look it up.
This is the 3 minute final.
Oh, I'm not defending myself here. So there was the first episode of the ad hominem, courtesy of Kwaku. The second one happened only a few minutes later, and this is how that one sounded.
But I would, at this juncture, like to ask, can we at this point agree at least to stop whatever is happening with the videos and the accusations between you?
He defended a guy who chopped up his sister and put her in a freezer. That's a record. It's a real thing.
That's his job. That's his job. He's a defender. So listen. Can we agree? Can we agree to stop the videos that show up at?
So that's basically how it sounded the second time. And you could hear the disapprobation of the audience even better the second time. First time it was there. Second time, you could definitely hear it even on the microphone. So there we have Kwaku bringing up this case in which I was involved some time ago. Okay, now for the backstory on this case, the case of the boy who killed his little sister. It was November of 2001, exactly 20 years prior to the debate that I had with the Midnight Mormons in Salt Lake City, which was November of 2021. Ironically, coincidentally, 20 years to the month prior to that the small community in which I practice law was rocked by a murder of such proportions that nobody could believe it. We wouldn't be able to believe it in a bigger community, but here in the small community, nothing like this, to my recollection, had ever occurred. And what it was this: a 13-year-old boy left at home with his 9-year-old sister, ended up stabbing her approximately 20 times, killing her in the process, and then trying to put her body into the freezer. Yeah, you can imagine how that would rock any community, especially a small community, a farming community like the one in which I lived at the time and in which I practiced law. So here is the way that the local newspaper, the Post-Intelligencer, the Seattle PI, covered this case. This is a story, once again, from the Seattle Post-Intelligencer. Gordy Holt is the reporter. November 15th, 2001 is the date. One neighbor called him sullen. Another said he was a playful teenager who loved to compete and often turned his summer lawn mowing chore into a race to finish first. This is obviously a description of the young boy. Whatever the truth, a 13-year-old Mount Baker Middle School student is now in juvenile detention, about to be charged with stabbing his little sister to death. At the boy's first court appearance in Skagit County Superior Court yesterday, bail was set at $500,000. The youngster will be arraigned Tuesday. It's a shock to all their friends, neighbor Debbie Sears said yesterday as she delivered a small bouquet of pink and white flowers to the East First Street house where the children lived with their mother. Police say the boy placed the 911 call. Once again, police say the boy placed the 911 call that summoned medics and police to the family's white frame house shortly after 4 p.m. Wednesday. I emphasize that because it's not that frequent that the perpetrator is the one who makes the 911 call, but that's what happened here. When they got inside, they found an 8-year-old girl dead. She was 8, not 9. My mistake, said Lieutenant Jerry Dodd of the Mount Vernon Police Department. There were multiple stab wounds to the body, and a knife was recovered. The boy was taken into custody without incident. The killing was the first in this community along the Skagit River, about 60 miles north of Seattle, in 3 years. And it may have been the first murder in 3 years, but it was definitely the first that was this atrocious in perhaps forever. The children's father lives in California, single mom. And Dodd said the children were home alone while their mother worked nearby. On Wednesday afternoon, on what had been a wet but uneventful day, Brenda Hernandez was tending the Moonin Caster cleaners counter next door to the children's home when sirens whined and East First Street filled with emergency vehicles. I ran to the window and all of a sudden there were 8 cop cars out there, she said. Hernandez could not remember meeting the children's mother, but she recognized the children and just recently listened to the little girl's sales pitch on behalf of Madison Elementary School. She was selling little gift things, candies and stuff for Christmas, Hernandez said. It was a fundraising thing for school. She was such a sweet little kid. The child's death and the likelihood that her brother would be charged with the crime made no sense to those who knew the children. She was an excellent student, a great kid, said Bob Records, the principal at Madison Elementary School. Kevin Tate, a spokesman for the school district, said the boys' Mount Baker middle school teachers had trouble connecting the event with the boy they knew. There was just no sign of anything like this, Tate said. Everybody's in shock. Neighbor Paul Walton, who rescued the family's 2 dogs, Apollo the Rottweiler and Molly the Black Lab Terrier mix, when they escaped their backyard pen, worried about the boy who sometimes seemed sullen, he said. He is small for his age, but his mother always said he was strong, like his father, Walton said. Under the roof of her broad-covered porch across East First Street from the children's house, Esther Flores said she knew the boy only through his summer lawn mowing chores. He'd make a game of it, she said. I'd be out mowing my lawn, and he'd race me, and usually win. My lawn is bigger. Then he'd jump up and down and make fun of us, making muscles. Flores said the boy and his family were quiet people who kept to themselves. Leonard and Arlene Kaiser, both 82, are as shocked as any of the neighbors. The Kaisers have lived in the house next door to the children's for 51 years. There have been quite a lot of changes around here since we moved in, Leonard Kaiser said, but this is awful. They seem to be such good kids, really good kids. And that ends the story from the Seattle Post-Intelligencer dated November 15th, 2001. So what ended up happening is that this young boy did end up getting charged with murder in the first degree in juvenile court. I did not represent him at the time. He was represented by the public defender's office, and he was represented specifically by Keith Tyne, a good friend of mine, very good attorney, smart guy. And you'll see a picture of him in some of the videos I have lined up to show you regarding this story. So what ended up happening is that this young boy, 13 years of age, did get charged with murder in the first degree for the slaying of his little sister. He was represented by the public defender's office. I did not represent him at the time, and the underlying charge that would come later. But the big decision that had to be made was whether the prosecutor was going to charge this 13-year-old boy as an adult or allow him to proceed through juvenile court as a juvenile. Obviously, being charged as a juvenile is much better than being charged and prosecuted as an adult, because you're going to go to prison a lot longer as an adult than you will as a juvenile. As it was, a deal was reached whereby he pleaded guilty to murder in the first degree as a juvenile, and he did what is called juvie life. In other words, he did the longest sentence that you can do as a juvenile, which is up to the age of 21. And at the 21st birthday of a person, juvenile court, the juvenile system loses jurisdiction over an individual. And that is why you can only serve up to your 21st birthday in juvenile detention. And that is what happened in this case. This young man was sentenced to juvie life. He was incarcerated until he was 21, and then he was released once again to society, where he apparently did a great job in society. He did not have any kind of recidivism. He didn't get in trouble with the law. He had no history before this, no history after this. This was an absolutely crazy, outlandish, violent, horrific exception to the way he conducted himself every day of his life. And so that also, I think, played into how it was that his attorney, Keith Tyne, was able to get him this deal of juvie life. Once again, much better than if he had been prosecuted as an adult. This young man was sentenced to juvie life, i.e. to the age of 21, which I think in his case was a total of between 7 and 8 years. He was 13 when he committed the murder. He served his sentence. He did exceptionally well, apparently, in juvenile incarceration, JRA. And then he was released on his 21st birthday. All of this, of course, happening without my knowledge. It's over here. I'm busy doing my private practice, and I don't have anything to do with this case until October of 2017, that much later. And in October of 2017, I get a call from a woman who wants to meet with me and see about retaining my services as a private attorney to see if I can seal the court record on her son's conviction and also vacate that conviction. I'll explain what that means in a second. I'm not sure if I knew exactly who this was until they were sitting here in my office, but this is the office they came to. Right over there was where the mom was seated, and right over there is where her now adult son of about 27 years old was seated. And that is when they described to me what it was that they wanted to see if I could do. And that's when I realized who it was who was sitting here in my office, that this was that case from 2001, November, of the boy who murdered his little sister. So I went into my computer to research the statutes related to juvenile offenses. Once again, juvenile offenses, they're a little bit easier to work with than adult offenses. They're going to give more leniency to juveniles than they are to adults. And that's the case even when it comes to sealing court files and vacating convictions. Now, sealing a court file in juvenile court, what that means is that nobody can come in off the street and just look through your file. As it is, anybody could go through the file, come off the street, ask for the name, ask for the number of the case, look it up, read everything that was in the court file. That could happen until and unless the case is sealed. Now, some of you may think that juvenile cases are automatically sealed, and there is some truth to that. There are juvenile cases that once a juvenile reaches a certain age of 18 or 21 or whatever it happens to be, that their convictions will be automatically sealed by court order. But those are for the less serious felony offenses. For the more serious felony offenses, they are not automatically sealed, and they will not become sealed unless a motion is made before a judge that the judge seal the file, which will then change its status so that nobody can go into the clerk's office and look up this case and go perusing through the file. It is sealed, and the only way they can do that is by getting a court order permitting them to review the court file. Vacating the conviction is something different. Vacating the conviction has to do not with the court file, but with that conviction for murder in the first degree that is on this young man's record, or at least it was on that young man's record before he retained me to get it vacated. What a vacation means. It's not an expungement, it's a vacation. And what it technically means is that it's sort of like going back in time to the date that he pleaded guilty. So he pleads guilty, you go back in time, nunc pro tunc is what we call it in the law, and his plea of guilty is withdrawn, and a plea of not guilty is inserted in its place, and then the charge is dismissed. So it does still show on the record that the charge was made, but it shows that the resolution of the charge was no longer conviction. It doesn't say guilty anymore. It says dismissed. And that's the effect of having a conviction vacated. So once again, they wanted to see if this young man's court file could be sealed and if his conviction could be vacated. I was not optimistic about this, but I went through the statute while they were sitting here, and much to my surprise, he qualified for both. I told you that juvenile law was a lot more lenient than adult law. Now, it appears, at least at the time, that juvenile law had a provision. If there were a felony that involved some kind of sex crime, then that could not be vacated. But at the time, they were okay with murder, even murder in the first degree, as long as it wasn't sexual in nature. So we were able to move the court and file a motion, which I did, not only to seal the court file, but also to vacate this young man's conviction. Now, this particular type of motion is not that novel. It's not that unusual. I've done a ton of them in private practice over the years, both for juveniles and for adults. And when I say for adults, adults do not qualify to have their case or court files sealed so that nobody can go in and look at them. That's only something that's available to juveniles, to my knowledge. However, for adults, under certain circumstances, they can have their convictions vacated as well. And I've done a ton of them. There's no big deal. There's no argument. Basically, if an individual qualifies under the law, then a prosecutor will agree to it. So as a general rule, these types of motions don't cause a lot of stress, especially for juveniles. The language is mandatory, by which I mean the judge does not even have the option of saying no. The judge cannot deny the motion as long as the juvenile qualifies under the law. And so the statute says that as long as the juvenile qualifies under the law to have the file sealed and to have the conviction vacated, then the judge shall grant the motion. It's not may grant the motion. It's not discretionary. It's mandatory. The judge has to grant that motion. So we filed the motion, and here's what happens, okay? When I file a motion, when anybody files a motion, you have to give sufficient advance notice to the other side that they can file a response, that they can have it filed with the court, that they can prepare to argue the case when it comes up in front of the judge for a hearing. So once you file a motion, you have to note it for hearing a minimum of 9 business days in the future, so that the other party has plenty of time. That's what I did. So I file it, give lots of notice. We show up to court, and here's what I don't know. What I don't know is that the prosecutor has, the day before the hearing, sent out a letter to 11 news agencies in Western Washington about what this motion is doing. Because the prosecutor, and this is the elected prosecutor, by the way, not just some deputy, this is the elected prosecutor who made the decision to notify media, because he knew that as of the day that I was going to have this hearing, this case file would be sealed and nobody would be able to get into it from that time forth. Making it more injurious, in my opinion, was that the prosecutor not only sent out a letter to 11 news agencies, he also sent along with the letter a copy of the affidavit of probable cause from the court file, because it hasn't been sealed yet, right? So he can go in there, he can get the affidavit of probable cause, which is the synopsis of the facts of what happened, send it out to all these news agencies, and made it a huge news story in Western Washington. It got picked up in other places as well throughout the country. That's how big a story it was. And I've got a number of clips that are still available from the local news stations in Seattle regarding this motion that I brought on behalf of this client to seal his court file and have his conviction vacated. This first clip is from the CBS affiliate in Seattle, Cairo News, Channel 7.
It was a crime that grabbed headlines. A 14-year-old Skagit County boy convicted of murdering his sister back in 2001.
It's heartbreaking to sit there and know what had happened in that house.
Tonight, Stephen Rickards is out of jail and heading back before a judge. And new at 11 why his murder conviction could be wiped from his record. Rickards was sentenced as a juvenile and stayed in custody until the age of 21. Now he is an adult and he's asking for a clean slate.
Cairo 7's Jessica O spoke to neighbors who remember that brutal crime and has more on the push to keep the conviction intact.
Stephen Rickards is 29 years old now, and he'll be in court tomorrow afternoon. He's going to ask for his criminal record not only to be sealed, but to be vacated as well. The prosecutor in this county says he's concerned about that, as do neighbors who remember what happened 16 years ago. When everybody walks by, they always say, "Oh, is that the house?"
16 years later, the people in this quiet Western Washington town still want answers.
It's heartbreaking to sit there and know what had happened in that house.
Heartbreaking and still a mystery for Holly Van Esch, who grew up next door to 8-year-old Samantha Rickards and her older brother, Stephen.
We just never understood. We wanted to know why he did it.
November 2001, Stephen, who was 14 at the time, stabbed his sister more than 20 times. Her last words, "Call Mom." He told investigators voices in his head told him to do it.
I love my sister very much and did not mean to do this.
After serving a 7-year sentence, Stephen is now asking for his juvenile records to be sealed and vacated.
To me, yeah, that kind of bothers me a little bit.
It bothers Skagit County's prosecutor too, which Wyrick says certain juvenile crimes, especially crimes this horrific, shouldn't be erased. It wouldn't honor Samantha's memory.
She was just the sweetest little girl. She used to come over. She used to help my grandma with meals for my grandpa.
Those memories of her childhood friends still hit home.
Every single time I look over there, it reminds me.
She says Samantha won't be forgotten, even if her killer's criminal records are.
It's still in the back of my mind all the time. Till this day, it's shocking how something like this held on so strong. The prosecutor says this points to a bigger problem that he'd like to see change on a legislative level. The hearing, by the way, starts at 1:30 tomorrow afternoon. In Mount Vernon, Jessica O, Cairo 7 News.
Now, Rickard says he is hoping to work as a hearing instrument specialist. He wants his record sealed, his conviction vacated in order to pass a background check.
So that reporter who was reporting from the parking lot right outside the courthouse at night, that was the night before the hearing. I had no idea that was going on. I had no idea that the prosecutor had sent this letter out to 11 different news agencies to alert them to this hearing that was going on this motion that I was bringing on behalf of this client. Not until I got to court at 1:30 p.m. the next day, and all of a sudden there's all these news cameras there. Now, my client was not present. He doesn't have to be present. This is post-conviction relief. It's more in the nature of a civil kind of hearing. He wasn't there, but his mother was. And what makes this situation more complicated is the fact that the mother is a single mom. She's the mom of both the boy and the daughter. Her son murdered her daughter. And I remember more than once looking at her and thinking, what do you do with this as a parent? How do you deal with this as a parent? And I know I'm getting a little choked up now because I got choked up then. Well, I don't know what I would do, but I know what this woman did. And what she did was she supported her son 100% while he was in juvenile detention for those years. And after he got out, she supported him and she loved him and got him to the point where he could be a contributing member to society. And she wanted him to be able to work with her in the hearing aid business. He couldn't pass the background check, and that was the main reason for wanting to get his file sealed and his conviction vacated. And you will see her in a minute because she gets asked questions by reporters, and she does an incredible job of answering them. And if I was mad at the prosecutor's stunt about notifying the press about this, that was nothing compared to how upset she was at the prosecutor for this stunt. And you'll see some of that come out in some of the comments she makes. This next clip is from Fox 13 in Seattle.
Diane Fox says a psychotic break caused her son to do the unthinkable 15 years ago. 13-year-old Stephen Anthony Rickards called 911 saying he stabbed his 8-year-old sister Samantha and put her in the freezer. Samantha had been stabbed more than 20 times with a kitchen knife inside their Mount Vernon home.
I can't explain the amount of anguish we've gone through and that he's gone through it more than anyone.
Rickard's mother says he hasn't had a psychotic break since. The 29-year-old has been out of prison for 8 years now, working at one point as an electrician who has a wife and 2 kids.
I do not believe that this is a charge that should follow him for the rest of his life.
That's why they're fighting to wipe his murder conviction off his record.
State versus Stephen Rickards.
Rickards was not in court, but his attorney asked a judge to seal his case.
And that the court will order sealing of the record in this particular case.
A judge granting that seal because of state law. So it now means no one in the public can look up court documents on Rickards. And next month, he will ask a judge to vacate the offense, meaning a murder conviction would be wiped away from any background checks.
I think that there are certain types of crimes that should not be sealed.
Skagit County Prosecutor Rich Wyrick alerted the media ahead of today's hearing, saying the case should be of public interest.
Just the seriousness of the charge.
He wants state lawmakers to consider changing the law that allows serious crimes like murder convictions to essentially disappear. Neighbors who remember Samantha's killing agree.
You got somebody that could go nuts at any time, and something like this doesn't just happen once.
There's no reason to hold someone accountable for the rest of their life for what could happen or what might happen. It won't.
And she's angry with the prosecutor's office for spotlighting her son's case.
The grandstanding on the prosecutor's part is at the cost of crushing my family and myself once again.
The attorney for the family says he's now considering filing a complaint against Prosecutor Rich Wyrick, calling his move unethical. But Wyrick says he did nothing wrong. In Skagit County, Hannah Kim.
So that was the piece from Q13 in Seattle, Channel 13, Fox News. Now I want to go to a newspaper article dealing with the same hearing. So this is the Associated Press article published Thursday, October 12th, 2017 by Gene Johnson. It runs as follows. When he was 13, Stephen Anthony Rickards stabbed his little sister to death and put her body in a freezer. Now, 16 years later, Rickards has served his time and tried to overcome the tragedy. He got a house, steady work, and a family of his own. But his juvenile conviction had prevented him from obtaining a license necessary to work as a hearing specialist at his mother's audiology business. So he quietly asked the Skagit County Superior Court to seal his case and expunge his record, as allowed by Washington state law. Instead, one day before his court hearing this week, the Skagit County prosecutor, Richard Wyrick, alerted 11 news organizations that Rickards was trying to have the records sealed and sent them a detective's statement in support of an arrest warrant in the case. That's the affidavit of probable cause, lest the details of the crime be forgotten. I am sending this email to the media due to the fact that this office believes a change needs to be made by the legislature as it relates to the sealing and vacation of convictions of certain crimes by juveniles, he wrote. While this office is sensitive to juveniles being able to rehabilitate themselves and have their records sealed, this is not one of those cases. And when Rickards' mother, Diane Fox, and his attorney, Radio Free Mormon, exited the courtroom Thursday afternoon, they were met by a throng of television news cameras and reporters for whom they expressed their outrage at the prosecutor's actions. Radio Free Mormon said the prosecutor's actions may have broken legal ethics rules as well as state law, which prohibits the dissemination of juvenile court records except in certain circumstances. If Mr. Wyrick wants to change the law, let him go to the legislature and change the law, Radio Free Mormon said. He needs to uphold the law as written and not subvert it. The judge on Thursday agreed to seal the records, but delayed for a month a hearing on whether to vacate the conviction, which he ultimately did, I believe, in a case that now highlights the extent to which the law should accommodate the rehabilitation of even the most serious juvenile offenders. Wyrick said after the hearing he did not believe he had violated any ethical rules, but declined to discuss further whether the release of the arrest warrant declaration was improper under the law. He said he doesn't know anything about Rickards, but that it was in the public interest for information about his crime to be available. There are certain types of crimes that should not be sealed, he said. Rickards, 29, pleaded guilty in 2002 after telling investigators he had killed his 8-year-old sister, Samantha, because he felt suicidal, but didn't believe he could kill himself. Experts determined he had suffered a psychotic break, his mother said Thursday. Under Washington law, those convicted of even serious crimes, except for rape, may seek to have records of their cases sealed if they meet certain conditions, such as not committing any crimes for 5 years after their release and paying restitution. In addition, while juvenile court records are generally public, state law prohibits the dissemination of certain records, even where such records are located in public court files. So even though any reporters who wanted to review Rickard's case before Thursday could have, and even though news organizations published Rickard's name and the details of his crime after it happened, it was forbidden for the prosecutor to email the detective's arrest warrant application to reporters, RFM argued. The arrest warrant application was stamped confidential information. Now, remember this. The arrest warrant affidavit that the prosecutor is sending out to 11 news agencies in a juvenile case is stamped confidential information and noted secondary dissemination prohibited unless in compliance with state law. For Rickard's mother, it is painful to relive the case in court. The grandstanding on the prosecutor's part is at the cost of crushing my family and myself once again, Fox said. There are no other victims in this case. There was my daughter that I lost. There was my son that I lost for over 7 years. We are the victims here. The next clip is from Como Channel 4, the ABC affiliate in Seattle. And this is what they had to say about this hearing.
Today, a judge agreed to seal the juvenile record for a man convicted of killing his 8-year-old sister nearly 16 years ago. Stephen Rickards was 13. He served his time and was released from custody several years ago. Como's Steve McCarran has more on Rickards' quest to move forward with his life.
The case rocked Mount Vernon in November of 2001. Neighbors left stunned after learning a 13-year-old boy was accused of murdering his 8-year-old sister.
There's no words that can explain to another child that one child took the life of another child.
Years after Stephen Rickards was convicted of the crime, served his time, and released from custody, his attorney was in court today hoping to have the 29-year-old's juvenile record sealed. In court documents, Rickards argued he spent 8 years in the community without committing another crime and is now trying to pass a background check to become a licensed hearing specialist.
Do we hold it against him forever, or do we let him live his life and be a good person? That's all he wants.
The judge granted Rickards' request, but held off on making a decision about whether to vacate his conviction. Skagit County's prosecutor says the case highlights a problem with current state law that allows records to be sealed in certain cases. He thinks the public should have the right to know if someone is convicted of first-degree murder when they're juvenile. He plans to ask state lawmakers next year to fix the law.
The legislature has to decide what they want. If they want this, then they can continue to have it.
Rickards' mother and attorney take issue with how the prosecutor informed the public about today's hearing. They believe he wrongly shared Rickards' arrest warrant from 16 years ago with the media.
You seek to crucify him for exercising the right given to him by the judicial system. He's not asking for anything special. He's asking for what was promised him in the year that he was released.
They're now exploring options to see if prosecutor Richard Wyrick should potentially face consequences for his actions. Wyrick doesn't think he did anything wrong.
No.
Steve McCarran, Como News.
So there is the last video clip dealing with the news coverage of that hearing. There was a complaint filed against the prosecutor. I'm not sure what happened to it. My recollection is probably that nothing happened because he's the prosecutor and he can get away with things that normal people can't. But regardless, that was the situation that was ongoing in my life back in 2017. And that's what Kwaku L was referencing in the debate from November of 2021. The irony being that Kwaku L framed this entire ad hominem argument he was making against me, that because I represented this young man in trying to, and successfully, by the way, getting his court file sealed and his conviction vacated, that showed I had a lack of care for humanity and the divinity of the human soul. Well, I will tell you, regardless of what I think about humanity or people's souls, I can tell you without hesitation that that young man's mother taught me what the meaning of Christlike love is. I don't know that I could do that. All I know is that she did that. She loved her boy even after her boy killed her daughter. I can't imagine that. I can't imagine being put in that position. But she did it so strong and so hard and so well, her love of her boy, in spite of that, that he ended up being successful in life. And that was something that taught me a lesson about the gospel, about Jesus Christ, about the love that passes all understanding. I know it's the peace that passes all understanding, but this is the love that passes all understanding. And I saw it in a human being who sat in my office and talked to me, and who you saw in the courtroom being filmed and talking to the reporters about why it was that her son should be allowed a second chance, even after he had murdered her daughter. Amazing. My hat is off to you, Diane Fox. Now, to close the show, I've got one more video clip to play for you, because as I was going back and doing research, I discovered a video clip I had never seen before. It turns out that this show called Crime Watch Daily had covered this hearing as well as other hearings. And what they do is they have two attorneys on. In this case, one's a guy, one's a gal, and there's a host, and they're talking about the facts of the different case, and they get into arguments about which side should win. As I happen to believe, the guy, the male lawyer, ends up getting the best of the argument because he's arguing my side. So here's the clip from Crime Watch Daily about this case.
Our next story out of Washington State. That's where police say 13-year-old Stephen Rickards stabbed his sister more than 20 times before trying to hide her body in a freezer. He would ultimately serve 7 years for the murder. Now he's 29, out of prison, married with 2 children, and he's filed a motion to seal his records and have his conviction vacated. The reason? He can't seem to get a job because he always fails the background check. So the question is, should violent crimes like this be hidden from the public if the suspect was a minor? Guys, his mother is actually supporting him.
I do not believe that this is a charge that should follow him for the rest of his life.
Should these records be sealed?
Chris, that question strikes right at the heart of the purpose of our justice system. It is to try and protect society from danger. And this crime in particular was an extremely horrific crime. Someone being killed, stabbed 20 times.
Bob Rickards says the murder was a psychotic break. He served his time. Shouldn't he get a break? Shouldn't he be allowed to find a job?
Okay, so we have a little bit of a disagreement with Lonnie on this. The juvenile justice system says it's for rehabilitation of the juvenile, not punishment and deterrence for the community. And in addition to that, it ensures that the records of the juvenile are sealed, protected from disclosure by law enforcement authorities.
But he's not just asking that it be sealed, he's asking that the conviction be vacated.
That's also
That means it's like it never happened.
That
He's not
is the
saying
law. And in fact, isn't this what this kid did? Model prisoner. He's had no psychiatric history. He's been evaluated multiple times. And the only reason he wants to seal it now is that he wants to be able to become a hearing specialist to be able to help kids.
Let's say you have an 8-year-old daughter. Your 8-year-old daughter has some hearing issues. You go to a specialist to get her hearing tested. You send her off into the room with the hearing specialist. You wait outside. You decide what's going on. You go into the room. She's laying there in a pool of blood, stabbed 20 times.
But that could happen, Bob.
That could happen.
That can happen, and it can happen
We've
with
seen
any
it happen.
random person.
How would you like to find?
Let me I didn't even get the chance to respond to it yet. It could happen randomly. We have the sensationalism. The fact of the matter is, the level of recidivism on murder cases is almost zil.
But we do those stories on the show. You've seen them, Bob.
It certainly happens, but you have to balance the interests here. What do you think? He's going to walk down the street with a sign that says, "I murdered my sister," put a scarlet M on his chest? You have to let the guy have an opportunity. He's demonstrated he's worthy of this.
But he stabbed his kid sister to death.
That's right. And you can raise your voice all you want. It does not change the facts that if that was your daughter that had just been stabbed by this person and you found out that he had done it before and that you were not able to know about that and he had been able to get a license to be in close contact with other children, yes, it was a psychotic break. Why might it not happen again? Why might not being with another 8-year-old girl trigger the exact same thing? There are no guarantees.
Okay.
And you cannot wipe that out.
Let me know when you're done.
Cannot make that go away just because you seal the record.
Okay, here you go. Here's the fact, Lonnie. The law says he can do it. Period. Full stop.
Lonnie, Bob, thank you very much for the spirited debate. Appreciate it very much.
You bet.
Okay. Now we want to hear from you. Do you think his conviction should be wiped clean? Sound off right now on our Facebook page. For more information on these stories, you can go to wildabouttrial.com or crimewatchdaily.com.
So there was the spirited debate about the issue on Crime Watch Daily. Once again, I come down on the side of the male lawyer. He's arguing my side of the case. But I do recognize that other people can have different views on it Please let me know what you think in the comments section about this case. I want to thank all the listeners and viewers of this show, and a special thanks to those of you who have gone to radiofreemormon.org, clicked the donate button, and made a donation to the program. If you have not yet made a donation, may I encourage you to go to radiofreemormon.org today, click the donate button, and make a donation. If you can make a monthly continuing donation, that is optimal, although any donation you can make will be greatly appreciated. Whatever you can afford. Your donations do keep Radio Free Mormon broadcasting behind enemy lines. Please also remember to click like, please hit subscribe, please tell your friends about this show, and share the good word of Radio Free Mormon wherever you go. Well, that's about all for tonight. Thank you for watching. Until next time, this is Radio Free Mormon, signing off the air.